Welcome, everyone. We have a very interesting topic today, which is moot courts. I have invited today Ataul Karim to chat with us on this topic. And as you will see, this is something you can incorporate with your class in a university or with your team in a company. You can even create several teams or having several groups being involved to deal with an important topic. It has so many benefits, and we will hear about them today. Ataul Karim, who is our guest, is a lawyer, academic, and a legal researcher. He worked in several academic and research positions, and I'm going to give you some examples. He's been a senior lecturer at law and East West University in Bangladesh, a tutor at the LLM program in IP and competition, the MIPLC in Germany. Also IPR Policy researcher at Ericsson, where we got to know each other. He has been afterwards consultant at WIPO in Switzerland, and he obtained an LLB with honors and an LLM from the University of Dhaka, an LLM in IP, patents and design law from the WIPO Academy and Ankara University, and an LLM in IP and competition law from MIPLC-Max Planck Institute for Innovation and Competition in Germany. So he was also awarded the University Grants Commission Gold Medal in 2016 for his research, publication, and law. And currently he's focused in IP, innovation, and competition law. As he has also some experience organizing moot courts, and I thought this is something we can all benefit from learning. So let me invite him to join us. Hi, Ataul. Welcome.
Thank you so much, Claudia, for having me.
I'm very excited to have this discussion with you, to have you here. As you know, today I would like to talk about moot courts, because I do think that this is something that can really be helpful in many ways, and we will learn today how. And I know that you have experience, and last time I could see it myself because you organize a moot court for the team, and we all enjoy it, and they learned a lot. So that's why I thought, why not to share your experience here and explain people what it is, how to build it themselves, and all the benefits that it has. So thanks for taking the time to talk to me.
Thank you so much, Claudia. I'm looking forward to having a great discussions today.
So let's start with definitions. What is a moot court?
Moot court or the mooting is the same.
Mm-hmm.
Generally, there is a hypothetical case which takes place in the appellate stage or in appellate body, and two parties compete each other's, presenting both the sides. Say, for example, one is petitioner or appellant, another is respondent or dependent. Based on a hypothetical situation, dealing with a legal problem which is happening in the reality, or which is growing, or there is a debate over it, or something that is unsettled yet. So on these kind of issues, there is this kind of case before the court.
Mm-hmm. Considering this, what are the benefits of doing a moot court or mooting?
A moot court can offer multiple benefits. I believe it may vary from the settings, like from the law schools, maybe from the practical aspects, maybe from the practitioners, or maybe from a particular industry. So normally what happens in the moot court setting, it is normally takes place in the law schools. During our studies, there are a lot of international moot court competition, which offers opportunity for the law students to attend. But I believe that this kind of customized moot court can be done, or mooting can be done in a different fields. even with the industry, to develop the skills of their employee, to develop the skills of the person who are working on the particular area.
Can you give me an example? How will that a company be able to use that?
For example, in the Moot code, on the hypothetical particular facts, one needs to research, find out the arguments in favor and against, develop kind of a critical thinkings, and also while presenting the case before a panel of judges, need to deal with the questions, tough questions from the judges. So I believe that all the skills here, researching, developing the arguments, and also knowing what are the arguments from the opposite sides, and also looking at the issue from the critical perspective, and also presentation before a panel. I think that this can also be done in industry settings, and this can also help the persons who are working in the industry or in the particular legal fields.
I see that. Yeah. But what about the obstacles? Because we're talking about benefits, but for sure there might be some obstacles. Which will that be?
I think the first obstacles is that it's really, really time consuming. That's the first thing. So the persons who are associated with, if they want to do it really in a good manner, taking the most benefit out of it, then they need to dedicate a lot of attention and the time. At the same time, and the second one, I would say it's about resource constraints. That can be from the perspective of the logistics and also from the financial perspectives. So the both of them, I think, are the main constraint. At the same time, also, I think that what they want to achieve from this setting, this kind of mooting setting, that needs to be identified first. And how that can be achieved, that's the real challenge in doing the Moot code. To design it in that manner, that's the real challenge.
I see. So I guess then it will make more sense when, at least in the context of a company, you do it for very important topics, or where you want to make sure that a topic is very well understood, analyzed, being seen from different perspectives, even for certain strategies that you want to see a challenge so that people can think in the counter arguments, so to say, but not necessary for non-important projects or topics.
Yeah, absolutely. You are absolutely right.
Okay, then you were talking about this challenge on from the goal to the how. What do you need to consider when you are developing this how?
Actually, the points I have made, these can also be developed through like presentation, developed through debates, like this kind of approaches. But how the Moot code is unique is that it has certain kind of decorum, it has certain kind of attitude, it has certain kind of etiquettes. I think that's the way how we need to formalize it, so that we can achieve the way we want to achieve, like respecting opinions from the others, at the same time establishing your or our own case. So I think that it can be, in my opinion, it can be mixed, both a bit of formals and a bit of relaxation in the industry setting. But in the law school, generally it is too formal.
Too formal. I hear a little bit critique here.
True.
What would you do differently then?
Yeah, maybe, for example, a particular technology company which is now working on tech licensing. That company may come up with a burning topic or issue that is still uncertain or unsettled, and there is a debate on the both from the perspective of the both sides. They can identify one or two legal issue, and they can divide their team, maybe like two or three in two teams, to have this kind of hypotheticals and this kind of research and writing the all the arguments that they have, like a kind of a formal arguments, and then they can start kind of a hypothetical oral hearing, so that at the end of the discussions, maybe they can assign someone to note down all the key important points and or what are the conclusions, which way it is going, and make a kind of a conclusions, and then make a list for them what would be the next course of actions on that. So I think, in my opinion, it can be used in a way that serve the benefit most in a particular company or particular research institution or educational institution.
I'm totally convinced now. So, what do I need to do to create a Mooting?
The first, we need to identify the prioritize or identify particular area that we are going to deal with, and try to write a hypothetical situation which has some practical relevance, of course, which is now happening around the world. Like this kind of, for example, if you think about AI and IP, if you think about uh, uh, data sharing and tech companies, if you think about technology licensing, there are a lot of discussions are going on this particular area. So just we can identify the particular area and then frame it to the particular issue, very specific issue, one or two, or maybe at best three. And then after that, we can divide the team, ideally two persons or three persons, one, two, maybe two persons from one side and the two person in another side, or three person each from one side or another side.
Okay,
And
I'm
then,
counting two in each part. So
yeah,
4 to 6 people.
yeah.
What else?
So let's say we decided three and three from each side, and then we need to give certain kind of responsibility. That, I mean, we can, of course, as an organizer, but normally what happens is that team decides the role and the responsibility within themselves.
Okay.
So one acts as a researcher, maybe two are representing the team as a presenter. If there are two issues, one person dealing with the one issue, that's enough. So from the both sides. And another thing happens in the law school is that they assign coach or guide. So what they do is they assign one person as a coach, like a senior student or or a faculty member, just to guide the team so that they remain in the right path. So
wait a second. Are we having two of them, one for each team, or one for both?
one for each team.
So we are already by 8 people, more or less. Huh. Just counting. I'm counting the name of people. What else?
And
A
then,
judge?
yes, and then the organizer generally they select the judge. In the panel, normally we have a setting of odd number, because odd number gives a benefit to give it a decision. If it is you can go in both way. One way is that you can go as per the ballot system. The ballot system is that if there are three judges, they give the ballot, like I'm giving in this side, another person giving this side, like this kind of way. Another way is that point system, where they give kind of a marking, and then you count the total marking, and the team which gets the total which gets the higher number, they they own the competition like this way. So this is, so just to step by step, I would say what we need to do, we need to prepare a particular problem, hypothetical problem, which has some practical relevance and setting in accordance with our priority. And then within the problem, we ask to deal with 2 or 3 issues, 1, 2, or 3 issues, and then we divide the team into the number that we want, maybe 2 or maybe 3, and the team has the responsibility to decide the role they want to play. One may become the researcher, other 2 may become the presenter, and then after that, organizer also develop a panel of judges, decide about the panel of judges. Normally in the panel of judges, it is in odd number to give a kind of a advantage, so that after the hearing they can decide in proper manner which team is better, which team has done better in this situation. That's it.
When you were talking about lawyers, right? So do we need to have lawyers with experience, lawyers who are still in the law school? What kind of requirements are needed for the participants?
So normally in the law schools, it can take place at any stage, early stage, and also in the upper stage of the graduate studies. But what happens is that those who those who have the basics of the particular area, that's enough. But I believe from the perspective of the industry setting, that it can also be uh, legal, but I would say maybe it's a bit ambitious. But sometimes I would say it can also be multidisciplinary. For example, the researcher, maybe, for example, if it is related to the law and economics, there could be a researcher from the economics background who would be able to help the lawyer, those who will be presenting, to have the better arguments. So I would say from the law school education, purely it's the legal background, people with the legal background. But from the industry setting, probably within the resource and employee, it can be a bit of relaxation of that and having a multidisciplinary approach as well.
So now everybody has their role. We have the participants, we have the guides, we have the panel of judges. Now what?
So that we can divide it into the 2 stage. In the first stage, we can have before the oral hearing, at least I would suggest maybe 2 weeks before or a month before, we can have an introductory session where a person who is acquainted with the basics of the Moot code can explain how about the basics of the Moot code and how it goes, what are the things that need to be remembered, and how it should be developed, how they should develop their arguments, write their memorials, and then we can have this kind of discussion, and the participant may have a lot of questions. We need to answer those questions and then finalize the date for the oral hearing. So at the second stage, we go for the oral hearing.
I'm thinking, because in terms of venues and people working more from home, I understand the first part could be done online, and the second part, ideally, I mean, I guess in principle you could do it also online, but preferably being physically there. What do you think? What have you seen so far?
Yeah, actually, the second part, first part can obviously be done with the online settings. That's more convenient, I think now. But at the same time, in the second part, if it would have been fun, it would be more fun if we do it in person. because in person it will make a lot of difference, in the sense that there will be a lot of interaction with the judges and the participants, and also there will be a lot of interaction with the teams as well. But at the context of the COVID, we have seen there have been some moot courts competition which held also the oral session via online. So, but, and then in that case, what they normally did was that whole team, they sat together. So that gives them a benefit to have a kind of a team discussions. And the judges panel, they were separate. So yeah, and also there were situation judges panel also were sitting in the same bench. So I think both is possible, but the in person one would be more fun.
I fully agree. Now we have, I'm thinking about the material, because you send the people this hypothetical, or the participants, you send them the hypothetical case or this hot topic, which still we are trying to define where to go. When do you send the material? Before or after the introduction, or during? How do you deal with this?
Normally the materials in our settings we do when we have this introductory session, but it can also be done beforehand, and that probably I think that would be beneficial as well, so that because the participant would be able to see the material first, and then when we'll have the introductory discussion, they will be able to ask the question and the queries they have. So both can be done, but sometimes what the moot court in a moot court competition they do, they send the material before, and then they have a kind of an introductory session before the oral hearing, having a kind of a break within the introductory session and also within the oral hearing.
Okay, before we talk about the break, how long should this introductory part last?
Normally, it depends upon the allocations of the time, but I believe that 2-3 hours would be a good session for the introduction, just giving them the basics about the moot and mooting, all these things. 2 hours, 3 hours would be good. And if it is more than that, and probably a participant might lose the interest.
Yeah, sounds like a lot of time. Just to explain how is it going to work. But yeah, I understand for big projects, it's definitely needed. What about how long does the oral hearing need to be?
That actually depends upon the allocations of the time that we allocate to the each motor. For example, if you have 2 issues, maybe we can decide the 10 minutes per issue. That means if one person is dealing with one issue, then that presenter has 10 minutes only to present the particular issue. And normally there is also after the hearing, just a issue argumentation, they have a rebuttal or closing statement. So we can divide that, for example, 10 minutes for the oral closing comments or closing statements or rebuttal, or maybe 5 minutes. But the allocation time of the time depends upon the setting that we want to do.
Okay. And what about the time needed this between the first one, the explanation, introduction, and the oral hearing? How much time should be there in between?
I think that should be a reasonable time. That should be giving the participants a reasonable time to prepare themselves. Normally, it can be, in international moot court setting with the law schools, they give 2-3 months to prepare.
Wow,
To
that's long.
prepare. Normal, yes, to prepare and go for the presentation. But that's a kind of a competition, like requesting all the memorials from the written submission from all over around the world. But in our industry setting, probably a month or 15 days, I think would be very reasonable.
Mm-hmm. Okay. Can you tell us a bit about the structure of the moot court in terms of process? Who speaks first? How long?
So we have two teams in appellate stage. One is appellant, another is respondent. So in the it is always appellant that they start the case. So like if we have two presenters, then the appellate teams start their case first, and then when both of the presenters finish their arguments, then the rest, and we have vice versa. In return, we have the respondent team, they start their case, but they present their case and they finish it. And then after that, if we decide to have a rebuttal session, we can also have a rebuttal session or closing statement session.
If I give the microphone to some people, they can talk for hours. Don't they have a time limit?
No. We can normally, for example, normally in some settings we do opening sessions for statement for the 5 minutes for the both the team. 5 minutes opening session, 5 minutes for appellant and also for the respondent. And then we also have, like, we can then decide each presenter how much time they will be allocated. Let's say 10 minutes. So we have 5 minutes, then 10 minutes for each two person, 20 minutes, 25 minutes, and then we can have a closing statement or rebuttal session for 5 minutes. So it's 30 minutes.
So you have, let's say, A and B. Then you have A 5 minutes, B 5 minutes, A 10 minutes, B 10 minutes. And then what? A
Then,
back? I mean, we can play this whole day long.
yeah. So there are different ways to set the timing in a moot session. Let's say we have two teams, team A and team B. Team A will be allocated for 20 minutes to present their case. So that each in the team A, if there are two presenters, one presenter will have 10 minutes per each. And then we'll turn to the team B. The team B, also they consist of two members. They will have 10 minutes each to present their case, meaning they will have 20 minutes. So team A has 20 minutes, team B has 20 minutes to present their case. And after that, we'll have a rebuttal session or closing session. So each team will also have 5 minutes, say, for example, 5 minutes for each team to close their argument and rebut the argument from the opposite sides. In that case, order of the our closing session would be team A first. They will go for closing session because they have presented first, and the team B will go for the closing session next because they have presented second.
Okay, so recap. Team A, team B. So team A, team B, they get 20 minutes because they are two people. So each of them 10 minutes, and they present the case. And then you have a rebuttal part, which is quite short. That would be A, B, A, B. 20, 25, 5.
Yeah.
Okay, I got it. Yeah. Then what happens with the judges?
So the role of the judges here is to see that how the presenters are making their case from the legal arguments, and at the same time how they are relating legal arguments with the hypothetical facts and making a conclusion by combining both the legal argument and hypothetical facts. So that's the role of the judges. But with the process, the judges make a kind of a active engagement with the presenter. So judges make active engagement with the presenters by raising some relevant question from their presentation and also from their facts.
All right. And when do they do it? I mean, they have these 20 minutes. Are they stealing from the 20 minutes, or is it after the 20 minutes, before the 5 minutes? When exactly is this taking place?
So they can intervene during the argumentation. Normally in the moot court setting, they can intervene anytime during the argumentation. But there is a rule also, both can be done. One rule is that during the argumentation and engagement with the judges, the time will be stopped. Counting the time, that will not be counted. But sometimes it can also be done in another way. Sometimes we see the judges has a long discussion. So to make sure that the participant has the proper time to present their case. So normally what we do is that we stop the time during the engagement of the judges, between the judges and the mooters.
Interesting. Is there anything that you think is missing that you would like to share with us regarding these mooting sessions?
Yeah, I would say from the two points maybe. One is that for the students, that this is important to make a balance. What is their core responsibility and what is their extracurricular responsibility? So making a kind of a balance between the study and the extracurricular activities like mooting, debating, and other things for the student. And I think if we are truly ambitious that we want to do some kind of exercise in the industry level, I think that one thing we can do is that we can try to be innovative. How that we can make it kind of a flexible enough so that people from the other backgrounds can also contribute, learn, and understand the dynamics of the legal problem that we have. Yeah.
Okay. Yes, to be taken into account. And finally, as you know, I usually ask this question in my interviews. Can you tell us about something that it's been a learning experience that you would like to share with us? Maybe this way we can all learn from it.
I think that it is all, I mean, still, and also at the time when I was studying the law, the balancing between the study and also the other co-curricular, extracurricular activities that helps to develop the soft skills. Balancing both of them, that is important. If I would have now have the opportunity to go back to the law school again, I would not only study, but my area of like legal study, I would not only do that, but I would also try to have opportunity to interact with the people, to do the networking, to understand and learn more how practical, how in real life things are going on, to understand more that, and also like developing skills that is like mooting, debating, and other kinds of soft skills, and try to have a balance, a kind of a wholesome approach to the life. I would say that I would now will be trying to achieve.
So is this something that you are now doing and you recommend others doing? To have this focus not only in the theory and the books, but also in the value of connecting to people and understanding more the practical sides of every topic, developing your own skills, social skills. Is this something that this is the path and you have learned from it and that you want to do and are doing?
Yeah, exactly. I have learned this with the process of the time, But I think from the now, I have been trying to practicing for some time, and I found it really useful. And this is the path I want to go on from the right. I mean, from the first few years I'm trying, but still I think that this is the path I want to move forward.
Very good. Thanks a lot for sharing with us and telling us all this experience regarding mooting that we will definitely follow. I hope some of you have been inspired and want to create your own mooting at your company or in research institution with your students. You know, there are so many possibilities. And yeah, so thanks so much, Ataul. It's a pleasure to have you here. As expected, we learned a lot. And to all of you, thanks a lot for listening to this interview, and talk to you soon. Bye-bye.
Bye-bye.